So let's look at slide 5. The early full-on ACA challenge. The court decision came out in 2012. This is the case known as National Federation of Independent Businesses versus Sebelius. Um, Sebelius was at that point the Secretary of Health and Human Services. Um, I mentioned before that oral arguments typically are assigned an hour, half an hour to each side to make their case before the Supreme Court. Everyone knew that this was a case of enormous importance, and that case was scheduled by the Supreme Court for 6 hours of oral argument over the course of 2 days. The case, like the statute, had lots and lots of issues, some of which were relatively straightforward, some of which were rather complicated. Lots and lots of friend of the court briefs saying, don't forget to think about this because the right outcome is this or that. The case really came down to two large issues and two large rulings. The first had to do with the individual mandate. The law's provision thought essential to the folks drafting and implementing the law at that time was the individual mandate. For a variety of reasons, many economic, the statute was predicated on the idea that everyone, or as close as possible to everyone, would obtain insurance from one of the providers whose plans were approved as being consistent with the contours of what the healthcare coverage thought to be necessary included. The individual mandate raised two pretty fundamental constitutional issues. Number one was, where does the federal government get the authority in the Constitution to issue such a complex and comprehensive statute regulating so much of the American economy? Again, remember from your civics classes that this country, in addition to being a federal republic, is one of limited government. So under the Constitution, principles of limited government, the question is always, where in the Constitution does the federal government get the authority to do A or B? Different people have different theories. It could come from the Commerce Clause, it could come from the Spending Clause. Suffice it to say, it was a serious issue that required serious attention. The other side of, or a parallel issue of importance was, what limits on the government's intrusion or ability to affect individuals? That is, what individual liberty implication is there for such an individual mandate? We are quite familiar with many of the controversies which surround individual liberty, and not just in criminal justice or in First Amendment freedom of speech issues or other constitutionally protected rights, but we know them in particular in terms of healthcare context. Perhaps no more heated issue than exists. There is probably no more heated issue than the question of reproduction and the right to, or limits on the right to abortion. There are similar rights and controversies surrounding, and probably will increase in the decades to come, issues around the end of life treatment decision making. It had been thought for a couple of generations, at least since the New Deal and the 1960s, that the issue about things like the individual mandate might not be so controversial. Again, they're in some ways analogous or similar to the Social Security program and Medicare programs, but nonetheless, it turned out that the individual mandate became one of the two central questions that were decided by the Supreme Court. And the decision adopted by five of the nine members of the court was that it was, as the court said, fairly reasonable to look at the penalty as, in fact, a tax. And the court said on that basis, it would uphold the individual mandate as being within the realm of approved actions in the past with regard to the levying of taxes by the federal government. That decision was 5-4, and there has been much written about and speculated about how Chief Justice John Roberts might have first been opposed to this reasoning, but ended up deciding that the court did not want to see the constitutional challenge take out the entire Obamacare or Affordable Care Act. The other very important issue decided by the Supreme Court was the state Medicaid expansion issue. And again, going back to the political dynamic for a moment, people who supported the existence of the Affordable Care Act were elated by the court's decision to uphold the individual mandate and therefore the entire statute. They paid less attention, but people that were opposed to the law were elated over the court's decision to strike down the state Medicaid expansion provisions in the law. The state Medicaid expansion said that if for states to continue to participate in the Medicaid program and therefore get federal funding that would pay for a part of, and in this case, a very substantial part of the cost of expansion, they had to make sure that their eligibility criteria included people whose income was up to 133% of the federal poverty level, as well as adults without children. That is not just low-income families, but adults as well. The court ruled 7-2 that state Medicaid expansion was invalid because it was overly coercive in terms of telling the state governments what to do. Another side of that issue is another argument in terms of that issue are things like, well, in fact, this state federal funding mechanism or stream is not that much different from countless other funding streams, whether it's about environmental protection or about highway construction or about special education or any number of other programs in which the federal government provides support for initiatives that are actually implemented at the state level. The court decided, for what reasons it tried to articulate, some agree with them, some understand them, accept them, some do not, that this was too coercive. The court also expressed concerns about the costs of Medicaid expansion. Again, the other side of that argument is the evidence that was ultimately produced. One independent, again, assuming that you believe that there's such a thing as independent analysis by the Congressional Budget Office and by the RAND Corporation, a private sector think tank and research group, both found that it was not going to be a costly impact on the states. In fact, it found that the cost associated with Medicaid expansion as provided in the statute was either minuscule, something like 0.08%, or would actually result in a savings. What is equally or more important are the consequences of the court's decision to invalidate the state Medicaid expansion. 14 states governed by Republicans have chosen not to expand their Medicaid eligibility requirements. And with the permission of the court, they are allowed to disregard that portion of the Affordable Care Act. The research shows that approximately 4.7 million people were not given the opportunity to obtain health insurance as a result of those 14 states' decisions. And research published in 2019 by the National Bureau of Economic Research estimated that approximately 15,700 people died as a result of not having access to the health care insurance that would have been made available had those 14 states expanded their Medicaid eligibility. Moving to the next challenge that we're going to look at, and that is the religious freedom challenge. This case was much more narrow in its scope. It's called the Hobby Lobby case. It was decided in 2014. The issue there was the preventive care part of the Affordable Care Act specification of what insurance had to cover included contraception. Hobby Lobby is a national corporation. It's what's called a closely held corporation. We'll talk about that in a moment. But it's not a small entity. There's about 500 stores, around 13,000 employees, and it's called closely held, meaning that it doesn't have stock that's publicly traded. It is owned by essentially one family, and it was the argument of that family that their religious beliefs would not countenance being supportive of contraception. The court ruled that under the Religious Freedom Restoration Act, again note, this is a statute that the court decided the case under. The argument was also expressed in terms of the freedom of free exercise of religion clause of the First Amendment. The court chose to decide it under the statute, which is what the courts do. That is, there's a tradition and a principle that if you can avoid a constitutional issue and decide something on a statutory basis, that's what the court will do. The court decided that the arguments of the plaintiffs, because it was a small owned company, were being infringed on by the requirement of contraception, and said that the existing, again, the outcome is relatively small in its impact, at least at that point. The court said that the statute had to fall in the sense that the statutory provisions that allowed exemptions for nonprofits because of religious beliefs had to be extended, in this case, to private corporations. And so that is what happened. What becomes more interesting from my perspective is the whole precedential issue about what does this court decision mean. If you're looking for the principle of the case and you want to use it in other environments, I can see people making arguments that their religious belief prevent coverage for same-sex couples or for treatments that they find problematic, such as blood transfusions or perhaps vaccinations. That's how court and precedent builds up, and that's where we stand at the end of the Hobby Lobby case.